Alright, so getting this straight out of the legal book, this is not legal advice, it's legal philosophy and legal history. Alright, first one. This book is called Latin for Lawyers. You can find it on Amazon. I think everybody should get one. First one, it's up on the board here, and I'll also put it up on the screen. Abusu ad usum non valet consequentia. A conclusion as to the use of a thing from its abuse is invalid. Meaning you can't keep a right from the people because you fear that some people may abuse that right. As long as it has not been taken from the people yet, they still have the right to use it. Alright, and then, like bitcoins, they can't just take that from us because they're afraid it may be used for laundering, or they're afraid it may be used for whatever. They have to prove that that's what it's being used for explicitly in most of the time. Okay, a communi observantia non est recedendum et minime mutandae sunt quae certam interpretationem habent. And what that means is common observance is not to be departed from, and things which have a certain meaning are to be changed as little as possible. So documents like the Constitution, we should take documents like the Constitution for what they are. We should it was meant to declare independence from a monarchy, from a type of nation that enslaves its people as subjects, to be subject to its laws, to be subject to its whatever. And Acta, exteriora, indicant, interiora, secreta. External actions show internal secrets. So what this means is that if you can tell what someone's goal is by seeing what they've done over and over, or seeing what they're doing. Like, if the judge doesn't like people that smoke, and like the people that keep going in there for marijuana keep getting the biggest sentence, you can tell what his goals are on the inside. And alright, the law in some cases judges of a man's previous intentions by his subsequent acts, and on this principle it was resolved in a well-known case that if a man abuse an authority given to him by the law, he becomes a trespasser, but if that he abuse an authority given to him by the party, he does not. So, just because you are the law, you are the enforcement of the law, says the police, doesn't mean they get to abuse that. Just because they are the enforcement does not mean they get to abuse that. They are just there to enforce the laws. They are not there to abuse the laws. They do not get to abuse them. That's not what they're there for. And they are trespassers when they do abuse them. They are literally trespassers within the eyes of the law. Alright. Actio non datur non damnificato. An action is not given to him who is not injured. Which means if there is no injury, there's no crime. There's no actionable thing that can happen based on somewhere where nobody was injured. If nobody was injured, there's no action to balance out. Because what you're doing, justice, the blind, she's supposed to be seeing which ones, she's supposed to be balancing it out so the crime and the punishment are equal. If there's no injury, there's no crime. So there's the blind thing, she's going to take shit off the scales because it doesn't balance. Alright. Actore non probante absolvitur reus. When the plaintiff does not prove his case, the defendant is acquitted. If they don't prove things against you, you're acquitted. And I actually skipped one, sorry. Actor sequitur forum rei. When the plaintiff follows the court, which means if someone wants to claim something against you, if the police want to write you a ticket, if the DA wants to do whatever for you, they need to be ready to prove that you've done that. They need to be ready to prove that you deserve to be put in jail for that, to get a charge for that, to get a fine for that, to get whatever you're getting. They need to be ready to prove it within the eyes of the court. They need to be ready to go through court proceedings to show that you have indeed broken some rule or injured somebody. And again, the next one, when the plaintiff does not prove his case, the defendant is acquitted. That one I should have read reversely. But Actore incumbent onus probandi, the burden of proof lies on the plaintiff. So not only do they, like, he needs to prove his case. There needs to be evidence. They need to, like, they need to be there to, if they're accusing you of something and you are guilty until proven innocent, they need to be there and to prove that you have done something. They aren't there to get to the next case and get home for dinner that night. They're there to prove that you have done something. That is their job, not your job to prove that you haven't done something. Their job to prove that you have done something. Alright. Actus curae nominem gravabit. An act of the court shall prejudice no one. The court is not a club of people that's getting the bad guys. They're there to hear the people speak on their cases, to speak about what has happened to them and what they've done wrong or not done wrong. That is what the court is for. It is not a club there deciding, oh, well, we're getting the bad guys. No, they may feel that way, but that's not what they are. They are no different than you. The people sitting behind you in the public audience is no different than the people writing, the court stenographer taking notes. They are all there. They are all... They're not any different in terms of what the court sees them, how the court should see them anyway. That they should all be seen as equals, things that you shouldn't be like, oh, well, we can do this to this person because he's in this position. That is not, that's prejudice. That is the definition of prejudice. So I think everybody should get these books. I will continue with more of these ideas and possibly get deeper into each one of these. But I just wanted to share these because most lawyers read this. They have books like this, and they don't help us. We need to learn this stuff so that we can help us. Just, all right, peace.